Alright people, so welcome to Jumbo IS and welcome to our current affairs lecture series. Now today we are going to cover Indian polity related current affairs from the past 1 week. If you have been following this lecture series, you know this that we cover current affairs subject wise. And in one lecture we cover one subject's current affairs from the past 1 week. Now today we are going to cover Indian polity related current affairs. Therefore, without further ado, without further delay, let's straight away dive into the lecture. Okay, so let's begin. So, Current Affairs Indian Polity, July Part 1, and here are the topics that we are going to cover. Number 1, proposed governance model for Ladakh. As you all know, after the abrogation of Article 370, Ladakh was made a UT, but people from Ladakh were demanding some form of representative democracy. Okay, they wanted some local autonomy. Okay, they did not want rule from Delhi. So, some compromise has been found. So, we'll talk about this. Then next topic is Supreme Court Draft AI Regulations 2026. Supreme Court has come out with rules as to how to use AI in the judicial system. How can you use it? How much you can use it in presenting arguments, case law, everything. So we'll talk about this. Then third topic is related to economic valuation of unpaid domestic labor. Basically, Supreme Court came out with a judgment regarding this topic, unpaid domestic labor of females. So we have to talk about this within the topic of Indian polity. Okay, so these are the three news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is proposed governance model for Ladakh. Now you see, Article 370 was abrogated in 2019. With the abrogation of Article 370, J&K Reorganization Act was passed, and the erstwhile state of Jammu and Kashmir was converted into two union territories. One union territory was that of Jammu and Kashmir, which has its own legislative assembly, and the other union territory was that of Ladakh, which was similar to the union territory of Chandigarh, Daman and Diu, Dadar and Nagar Haveli. Okay, now two UTs were created, J&K and Puducherry. Now, as far as J&K is concerned, well, J&K had some form of representative democracy. There is a chief minister, there are elections, there is a legislative assembly, much like Puducherry and Delhi. But Ladakh would be administered directly from Delhi, from center. Therefore, all things related to Ladakh would be handled by bureaucrats which would be subservient to the President of India or the Lieutenant Governor. Right? Now, Ladakhi people were demanding some form of representative democracy, some form of local autonomy. They wanted to be treated like other states of India. Now, the demand from Ladakhi people was that include Ladakh into 6th schedule. Okay. Now, there are certain tribal areas in Assam, Meghalaya, Tripura, Mizoram, which are put in 6th schedule. Okay. So, these tribal areas are given some local autonomy, because these four northeastern states have been given the protection of 6th schedule. Now, what is included in 6th schedule? We'll talk about this. But Ladakh was demanding a similar status as the status of tribal areas of northeast, okay, which have some local autonomy. They have their councils, regular elections take place. So they wanted that. Now, Ladakh is a sensitive region. It borders China as well as Pakistan. Therefore, we cannot give too much autonomy to that area. So therefore, the central government was resisting, but there were protests happening from Ladakhi people. Okay, so there was a compromise that was reached. Okay, we are not including Ladakh in 6th schedule, but we have given them some form of autonomy. So what is this formula? Let's talk about this. Okay, so proposed governance model for Ladakh. Following years of local protests, hunger strikes, shutdowns led by civil society groups like Leh Apex Body and Kargil Democratic Alliance, because Kargil is part of Ladakh, Ministry of Home Affairs released official minutes confirming a landmark compromise. Okay, now listen to me very carefully. You see, India is a federal country and India follows federalism. But you see, federalism is of two types. Okay, listen to me very carefully. This is very useful. Federalism is of two types: symmetric federalism, asymmetric federalism. Okay, symmetric means that all states are treated equal, all regions are treated equal. No region, no state, no province has special rights over the others. Okay, that is symmetric federalism. Do you think India follows symmetric federalism? No, India follows asymmetric federalism, where overall all states are equal, but to accommodate various regional interests, tribal interests, okay, some states have been given some special rights. Like tribal areas of northeastern states have been given some special rights. Before 2019, J&K was given some special rights. So India follows asymmetric federalism so as to accommodate the interests of different groups, diverse groups, regional groups in India, right? Now, this new compromise formula is an example of asymmetric federalism. This new compromise formula for Ladakh is an example of India's ability to accommodate divergent interest groups through its asymmetric federalism. Okay, so remember this term asymmetric federalism. Clear? In standard symmetric federation, all constituent states possess identical constitutional powers and relations with the center. However, in India, asymmetric federalism, where different regional units are granted distinct powers, protections, administrative status based on their specific historical, geographical, tribal, strategic context. Okay. Now, standard UT framework. Ladakh earlier was treated as a standard UT, much like Chandigarh. Okay. Because it was treated like Chandigarh, well, in Chandigarh, an administrator is appointed by the president and they directly administer Chandigarh. But Ladakh is different. It has different tribal groups, different tribal interests. So it requires a representative form of democracy. It cannot be handled by bureaucrats alone. People of Ladakh have different interests. They demanded democracy. Okay. So that is why we had to allow for asymmetric federalism to take over in case of Ladakh. Okay. Now, for Ladakh, we have created a sui generis model. Now, what do you mean by sui generis model? Well, sui generis model means one of its kind, a new model for Ladakh. Okay. There are different models for different states. Nagaland has a different model because Nagaland has been given some special rights. Manipur has been given some special rights, right? J&K was given some special rights. Now, Ladakh has been given a new kind of model. That is why it is called sui generis, new, one of its kind. Instead of executing a direct constitutional amendment to place Ladakh under 6th schedule, which was demanded by the civil society groups. 6th schedule, well, only 4 northeastern states have been put under 6th schedule: Assam, Meghalaya, Tripura and Mizoram. The center is deploying a customized model which is similar to Article 371, and under Article 371 A, B, C, D, E, F, G, H, well, different states have been given different rights. Okay, so we are giving Ladakh, well, that model which is pretty much similar to Article 371, not 6th schedule. Okay, so what are the core pillars of this sui generis model? Okay, number one, much similar to Article 371, Article 371 constitutional shield. This shield has been provided to Nagaland, Mizoram, Manipur. Okay, now what is this? Well, we are promising the people of Ladakh that no law of parliament which alters tribal customary law of Ladakhi people, okay, tribal laws, tribal customs, and all the other things. Anything related to ancient tribal law of Ladakhi people, no law of parliament shall be applicable to Ladakh if it has not received the permission of local council of Ladakh. So we will create a local council of Ladakh. Okay, and that local council will approve a parliamentary law if that parliamentary law interferes with tribal customary law and many other things. This provision is provided in Nagaland also. So we are going to give this to Ladakh. Okay, plus, well, you will reserve certain form of government employment for Ladakhi people. Nobody from outside can acquire immovable property. Okay, only Ladakhi people can acquire property in Ladakh. These kinds of protections are given to Ladakhi people. Then, direct democratic control over bureaucracy. As of today, bureaucracy of Ladakh is under Lieutenant Governor, who is under President of India. Ladakhi people were demanding autonomy, so government has promised that this local council will control bureaucracy. Okay, so this is there. Then 3, harmonization with local representative councils. Already there exists some councils. Kargil, there is a local tribal council of Kargil, local tribal council of Leh, right? We won't abolish those tribal councils. This new local council will coexist, okay, with distribution of powers between all these councils. You understand? So we won't abolish the previous councils. The previous councils and this new local council will coexist. This is the model that we are presenting to them, and they have pretty much accepted this. Okay, they wanted these two things, 1 and 2. Clear? Now I have given this table also in your notes. This table reveals or tells us if government had accepted the demand of 6th schedule, then what would have happened? And now what is happening with this new sui generis model? So the difference between 6th schedule demand and the new sui generis model. Okay, so this is the 6th schedule. Requires amending constitution. Okay, if you have to include Ladakh into 6th schedule, well, you had to amend the constitution. This doesn't require constitutional amendment. Okay, this would have created autonomous district councils like in Assam, Meghalaya. This doesn't need to, I mean, there is no requirement of creating autonomous district councils. You just need one local council representing the entire Ladakh, like a legislative assembly. So instead of multiple autonomous district councils for different tribes, you have one council. Okay, administrative control. Even if Ladakh was included in 6th schedule, the ultimate administrative authority would have lied with the governor or lieutenant governor. Over here, well, it lies with the local council, executive oversight over the bureaucracy. And geopolitical security, well, risks creating fragmented, because if Ladakh would have had multiple tribal councils, that would have fragmented Ladakh, and Ladakh is in a sensitive location. Therefore, we cannot afford to have divisions in Ladakh because our enemies, China and Pakistan, would exploit that. So we need one unified council for Ladakh. So this is a better formula. Clear? Though I don't need to tell this to you, Ladakh is important geopolitically because this entire UT of Ladakh borders Pakistan, POK, and it borders China, Xinjiang province of China. Okay, Galwan is over here only. So this is the critical strategic importance of Ladakh. Clear? That's about it. That's all you need to know. Now let's quickly shift our focus to next news item, and that is Supreme Court draft AI regulations 2026. You see, Supreme Court realizes this fact that as far as the efficiency of our courts are concerned, and it's not just Supreme Court, even high courts, district courts, and subordinate judiciary, well, our courts are not that efficient. Okay. Now, some people are advising the Supreme Court that if we inculcate AI into our judiciary, that would improve efficiency and would improve the efficiency functioning of the court judicial system in India, and can also solve the problem of pendency of cases. Because our judicial system is not that efficient, there is this huge line backlog of cases whose judgments, whose adjudication is pending, right? We need to make our justice system more efficient. Therefore, well, the courts of India were flirting with this idea of using AI. But there was a problem. The thing is that recently a lower court used AI for basically interpreting a case law. In that case, AI turned out to be faulty. And the judgment relied on that faulty case law to deliver a judgment. That created a huge controversy because the AI gave a faulty errorful opinion. You use that opinion, you use that case law generated by a large language model, AI, thinking that it should be true. When is ChatGPT wrong? You just thought that, and based on that, you delivered a judgment. A lower court, district court, delivered a judgment, and well, it created controversy because that case law was faulty. Because AI LLMs are known to hallucinate when they give wrong answers, okay, imaginary answers. So therefore, we have to be careful. So Supreme Court realizes the importance of AI, but it also knows that AI can be faulty. Therefore, Supreme Court has come out with a middle path. It has released a set of guidelines as to how to use AI so that you improve the efficiency of the judicial system, but you're not over dependent on AI so that, well, eventually faulty judgments are also being adjudicated, given. Okay, we have to be careful. So these draft guidelines released by Supreme Court are choosing that middle path. So what are these draft guidelines? Let's talk about this very quickly, okay? So Supreme Court draft AI regulations 2026. Now, on June 3rd, Supreme Court AI's committee officially released draft regulations for use of AI in courts for public and stakeholder consultation. Why? Well, we need these rules. what is the reason why we need these rules? What is the need? First of all, pendency of cases is a huge problem. So we want our judicial system to be efficient, and AI can make it efficient. But we have to be careful also. We need these rules so that we are not over dependent on AI. In early 2026, Supreme Court was forced to issue strict notices after a subordinate trial court unwittingly relied on a non-existent case law. Okay, the judge relied on that AI case law and gave a judgment. So Supreme Court had to issue a notice. So we have to be careful also. Hence, we need these proper rules. Clear? Now, what are the core pillars of these rules released by Supreme Court? First of all, Supreme Court says that, well, there shall be principle of human primacy. AI must function strictly as an assistive tool. Okay? Just as an assistant. You cannot supplant or substitute AI for judges or lawyers. Okay? AI will assist lawyers or judges, but AI won't act as lawyers or judges. Clear? So use it in that way. Then, strict liability regime. Well, if a lawyer uses AI and that AI generated a faulty answer and the lawyer submitted that answer in the court, well, the lawyer cannot say, sir, sorry, it was ChatGPT's fault. I'm not at fault. Well, the court will say, no, you are at fault because you had to use AI as an assistant. You are a lawyer. If AI is giving wrong answers, as a lawyer, you should know what is the wrong answer, what is the right answer. So lawyer would be held liable and punishment would be given to lawyer, not ChatGPT. Same applies to judges also. Okay, so a strict liability has been given. Earlier, lawyers and judges used to say, well, the fault lies with ChatGPT, so punish ChatGPT. And how can you punish ChatGPT? Supreme Court guidelines say, no, the liability lies with the user of AI. Okay, the framework closes the accountability vacuum by introducing a strict no-fault liability standard for judges, court officials, and lawyers. Clear? Plus, well, there was this very famous judgment in 2016 called the Anita Kushwaha judgment. In that, the Supreme Court said that access to justice is a fundamental right under Article 21, right to life. Therefore, use or design AI in such a way that it makes justice accessible to most people and it does not widen the already existing digital divide. Use it in such a way that most people feel welcome. Nobody is excluded from this system. Okay, if you are not literate in terms of using AI, well, you shouldn't be excluded. Use AI in such a way. If it is found by Supreme Court that usage of AI is excluding those people who are not trained in AI or who are not familiar with AI, it is excluding justice to those people. That AI will be struck down. Okay, so use AI in such a way that it increases the accessibility of justice. Right? Okay. Now, Supreme Court has also given the permissible usage of AI and which is absolutely prohibited. Okay. So this column talks about what kind of AI use is permitted and this talks about what kind of AI use is completely prohibited. Okay. So legal research, retrieval, automated searching a previous judgment, this is allowed. Language translation is allowed. E-court, case management. Okay. Presenting cases in table form, extracting cases, this is allowed. Deploying conversational AI assistants and voice tools to aid person with disabilities. So people who speak another language, well, translation of their mother tongue, or people with disabilities, well, AI voice assistant can be used to help them argue their case. Okay, this is allowed. But automated judgments is not allowed. Credibility evaluation. AI systems cannot be used to assess witness credibility. You won't use AI to check whether the witness is lying or not. No. Risk scoring restrictions. Utilizing opaque black box risk scoring to determine the defendant's flight risk. When a defendant is applying for bail, you are using AI to check whether on bail will he flee or not. You cannot use it. You cannot use it for surveillance. This is completely prohibited. Right? Now, also, the Supreme Court in its guidelines said that you need a mandatory disclosure framework. What is that? These are lawyers' obligations and these are the institutional duties of a court. So a lawyer must file a formal certificate declaring if AI was utilized to prepare any arguments or evidence. So if a lawyer has used AI in a particular case, he has to declare it. Okay, the judges should know. This is the disclosure framework. Benches must explicitly state in their orders if an AI tool was used to perform material data analysis or case management tracking. If judges had used AI, they will write that in their judgment. Supreme Court made it really clear that if you're using AI, the public has the right to know. Okay, so mandatory disclosure norms, right? Plus, well, the Supreme Court is also saying that we will create a permanent AI institutions. Okay, so Supreme Court will act as an apex body. Then we'll create High Court AI secretaries, which will manage AI in judiciary. Then we will create Center for Research and Excellence on AI. This center will work on how AI can be useful for judiciary. Okay, so we will create these institutions so that AI is integrated with judiciary properly. So Supreme Court is creating a permanent institutional framework as well. Okay, now what more can be done? This is the way forward. Please do not overuse AI. You need to balance efficiency with judicial independence, human primacy. Okay, don't completely rely on AI. That tomorrow AI is delivering judgment, not the judges, human judges. Formulating a comprehensive safe harbor rule. Currently, if a lawyer uses faulty answer given by AI, that lawyer will be held accountable. Well, if that lawyer was not deliberately doing it, it was an honest mistake, that lawyer shouldn't be punished. So therefore there should be some safe harbor also. Okay, that's the way forward that is being argued. Okay, but I don't agree with this. Okay, plus, well, bridging infrastructure disparities. AI is all fine in courts of India, but there are certain courts in India which lack internet access. How would you deploy AI in that? So bridge this infrastructure disparity. Implement e-courts project throughout the territory of India. Make sense? Okay, that's about it. And now let's quickly shift our focus to next news item, and that is economic valuation of unpaid domestic labor. So let me explain this topic in brief. Okay, you see, as per Motor Vehicles Act, okay, if there is a road accident, all these insurance companies which provide insurance claims, if, well, a person died in that motor accident, insurance companies give you insurance claims. Okay, now if the person who died was the sole breadwinner of the family, more money is given to the family. If it was a female which was not the breadwinner, she just performed, she was a home worker, then the money paid by insurance companies is less. So you imagine the thing. Okay, your insurance claim is more if there is death of a breadwinner in a family. If it is a female who was a homemaker, well, then insurance claim is not that high. Now, someone filed a case in Supreme Court saying that it is violation of right to equality, Article 14. It is discrimination against women. Because you don't consider homework as work, that is why you are paying lower compensation as compared to the compensation given for in case there is a death of a breadwinner of a family, right? So Supreme Court struck this provision down. And Supreme Court said, no, this is clear-cut violation of Article 14, right to equality. You will pay more compensation in case of a home worker dying, a female dying, because we will consider unpaid domestic labor as labor. Okay, we will assign a monetary value to that, and based on that monetary value, money would be paid. Clear? So this is the entire thing. So let's talk about unpaid domestic labor. What are the societal norms? What are the issues? And what Supreme Court has said all of this, about this. Okay, so let's begin. So economic valuation of unpaid domestic labor. So this is the landmark judgment of Supreme Court Shishupal versus Surji. Apex Court ruled that attributing a nil, sometimes no money is paid, or purely symbolic economic value to homemakers' labor in legal and insurance proceedings is discriminatory, violation of Article 14 and Article 15. Clear? Now, the Supreme Court said that you do not recognize homework, unpaid domestic work as work. This is wrong. Okay? Well, some research has been done in this matter, and some people have said that unpaid domestic labor has a monetary value also. Invisible GDP. It's called invisible GDP. Time use survey conducted by National Statistical Office. It highlights that Indian women spend an average of 299 minutes per day on unpaid domestic services, 134 minutes on unpaid caregiving services to elderly or children. Indian men just spend 97 minutes on domestic tasks and 76 minutes on caregiving. Okay. International Labour Organization estimates indicate that if women's unpaid care and domestic work was given monetary value, if you assign a monetary value to this work that is being done by women, you will add 10% to 15% more to India's GDP. So 10 to 15% of India's GDP, the value of that is equal to the value of unpaid work done by women if you assign a monetary value to it. If the women of that house did not perform that work, the men of that house would have had to hire caregivers at a proper wage rate. Okay, they would have had to hire them, they would have had to spend money. Clear? But they are getting this from their women for free. Make sense? Now, there is this asymmetric labor extraction loop also. What does this mean? Homemakers perform cooking, cleaning, elder care, child care for zero wages. Because of that, men of the house do not have to hire professionals for these tasks. Okay? So there is no cost attached. Therefore, these men are ready to work at low wages also. Okay? If they had to hire these professionals, suppose these professionals costed around 10,000 per month. Let's suppose these men would demand wages which are at least more than 10,000. But now they are ready to work at 8,000 also because they don't have to spend this much money. So this is also a way through which companies keep wage cost low. Okay. Now, moving past ad hocism. So what is the Supreme Court's judgment? So Supreme Court says that now there will be a proper formula for determining the compensation for homemakers also. You will basically give them minimum skilled wage floor. So you will assume their labor at minimum wages. Whatever the minimum wage is given by the government, you will assume that. Plus, if the house is bigger, there are more members to the family, you would add a premium. And if that female had some educational degree, higher education, skill, then you will add more premium. More money would be paid if that female is well qualified. Okay, so this is the thing. Now, what are the challenges? Socio-economic challenges still exist. Patriarchal labor of love. Well, because of societal norms, it is considered that it is a female's duty out of her love and affection for her family that she has to do this physical work. This adds to, well, this is kind of a double burden on females, because females who have careers, they are still expected to perform domestic work. Therefore, it's like double burden on them. Men, on the other hand, can choose their careers and do not do anything in the house. But females are expected to do both. This puts a lot of burden on them. And informal care deficit also. Because the care workers are not formally employed, so they have no sick leave, they have no insurance, nothing of that sort. Okay. So, if a female who performs the entire domestic work of the household, if she gets ill, the entire household gets into disarray. So this is a challenge. Clear? Plus there is a way forward also, which is pretty simple. Okay. So way forward is given in your notes. Just go through that. Very simple to understand. Clear? And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I'm sure about it. Now, all you have to do is that you need to follow these two things. If you want to add more value to your preparation. Number one, well, be consistent and regular with this lecture series. And number two, revise this lecture from the notes provided by us. These notes are shared on our Telegram channel, and the link to our Telegram channel is provided in the comment section below. So make sure that you do this necessary revision if you want to retain these current affairs in your memory till your exams. All right, then. On that note, I'll be signing off with the promise of seeing you again with another set of news items. Thank you, everyone.